Madam Secretary, please call the roll.
Senator Gannon,
Here.
Senator Crawford, Senator Carter, Senator Coleman, Senator Koenig, Senator Rizzo, Senator Washington.
We have a quorum, and welcome back from spring break. We will be hearing Senate Bill 1415 and House Bill 720, House Bill 1749, and House Bill 1909. Senator Black, when you're ready to present Senate Bill 1415, you may proceed.
Good afternoon, Madam Chair, members of the committee. For the record, my name is Rusty Black, and I represent the 12th Senatorial District. Missouri election officials face rising challenges in recruiting enough workers to serve as election judges. Currently, all election judges are required to be registered voters in their county, which has prevented most active military service members and their spouses from working the polls. In order to allow these service members and their non-resident family members to be eligible to serve as election judges, I filed Senate Bill 1415, which applies very similar definitions to ones the General Assembly has already enacted for professional certificates to the qualifications for election judges. The language would amend the qualifications of election judges to add military service members domiciled in the state of Missouri, as well as resident military spouses and non-resident military spouses as persons eligible to serve as election judges, even if they maintain permanent residence and voter registration in another state. And as somebody that has 19 rural counties, and we do have people around Buchanan County that are fit this military service member group that we're talking about, we certainly need the help there, and those are certainly trustworthy people to go to and ask them to help run our elections. So I'd be happy to answer any questions.
Do we have any questions from the committee? Seeing none, we will be starting with witnesses in support, and then we will move to those in opposition. Okay. First person in support.
Thank you. Madam Chair, members of the committee, Chris Ropey here on behalf of Secure Democracy USA, which is a national organization that seeks to instill integrity back in our election process and build confidence back in that process. We are working on this legislation in support of Senator Black and appreciative of him bringing this forward. We obviously, with what he's got over in St. Joe with Rosecrans there, what you've got with Whiteman and Fort Leonard Wood, it seems silly as we are losing clerks at a rapid rate. It's just as hard. You will not find a clerk that doesn't tell you how hard it is to find election judges. So what better folks to serve in that capacity than our active military and their spouses, which a lot of them will keep their residency in another state while they're here on active duty, and this would just afford them the opportunity, if they would choose to be involved in that election process and help out the local election authorities. I would like to bring to your attention a possible technical amendment that I can visit with your staff afterwards to just clarify that we're not allowing people that don't live in the state of Missouri to do this, that it is only active military members and their spouses that do reside in the state of Missouri temporarily. But happy to get that cleared up and answer any questions.
Any questions from the committee? Seeing none, thank you. Next in support.
Elizabeth Franklin, thank you for allowing me to testify. Full disclosure, I am in the Senator's District, and I do appreciate this bill. I am testifying in support of it. As a former military member, I always kept my permanent residence in Missouri when I was stationed in other states, but I appreciate this. With mentioned earlier, the shortage of election workers, I think this is a great idea.
Thank you.
Do we leave our... Okay.
Yes. Any questions from the committee? Seeing none. Next in support.
Good afternoon.
Good afternoon.
My name is Marilyn McLeod. I'm the president of the League of Women Voters of Missouri. And definitely we would support this. We understand the issues that are happening for the clerks, and so this would be a positive addition. So we would support this.
Any questions from the committee? Seeing none. Thank you. Next in support.
Thank you, Madam Chair. Thank you, Senator, for proposing this bill. The Missouri Voter Protection Coalition, on whose behalf I'm testifying today. My name is Denise Lieberman, Director and Counsel of the Missouri Voter Protection Coalition. We go on the record in support of Senate Bill 1415, understanding the critical role that poll workers play in the elections process and the challenges faced by our local election authorities in obtaining sufficient poll workers to do this very critical job. We know as well that our election workers around the country are struggling to find sufficient poll workers. A recent national study found that approximately 20% of poll workers around the country are leaving those roles prior to the 2024 elections, and so appreciate the importance and timeliness of this provision.
Any questions for the witness? Seeing none. Thank you. Next in opposition. In support. Okay, opposition, first witness. Seeing none. Informational purposes only. Seeing none. Closing comments, Senator.
Thank you, Madam Chair, very much for hearing the bill.
There you go. Okay, Representative Falkner is going to present House Bill 1720. When you're ready, you may begin.
Thank you, Madam Chair, members of the committee. My name's Bill Falkner. I represent the 10th District. House Bill 1720, all it does is protect the information on students 17 and under that participate in a municipality, park board, city or town in participation. Like right now, if your child or grandchild is playing in like Summer Jam basketball that is sponsored by the city, that information can be sunshine. And so what we're trying to do here is protect the information so we don't have to, in today's times, I think that's very important. And so it's rather simple, but I think it's a much needed bill. And I dropped it to 17 because I didn't want to get into the 18 age because we consider them to be adults. So with that, I'm more than happy to take any questions.
Any questions for the representative? Seeing none. First witness in support.
Thank you, Madam Chair and members of the committee. Shannon Hawk, I'm here today on behalf of the Municipal League of Metro St. Louis and the Missouri Municipal League. You have seen this language before. This is not the first year. Thank you so much for sponsoring, and I also want to thank Senator Koenig, who has worked on it with us for years. That's all it really seeks to do, is protect the personal identifiable information of minors that's held by a city. There are other statutes, like if you look in the education statutes, there's specific language to protect that. It's all throughout the statutes, but for some reason it's not in the statutes relative to cities. So we actually learned about this when the mayor of Frontenac let us know that she had received a sunshine where they were wanting kids' information and they had to give it to them. So.
Okay. Any questions for the witness? Seeing none. Thank you, Shannon. Next in support of House Bill 1720. Seeing none. Next in opposition. First in opposition of 1720. Seeing none. Informational purposes only for House Bill 1720. Seeing none. Representative, do you have closing comments?
I would just like to thank the committee for letting me give House Bill 1720, and I'd like to also give my appreciation to the senator. We worked on this last year, and so with that, thank you very much.
Okay. Representative Haffner is going to present House Bill 1749. And Representative, when you're ready, you may proceed. Again, I want to remind all witnesses that come forward, either in support or opposition, informational purposes, please state your name and fill out a witness form.
Well, Madam Chair and the committee, good afternoon. Great to be here. For the record, Representative Mike Haffner, representing Missouri's 55th Legislative District in Cass County. And I'm going to be presenting House Bill 1749. I'm going to start out by saying this is a complex bill. This is a working project that took about 6 years. And it is complex, but nothing's more important than protecting our Constitution. This bill will ensure that Missourians are in control of the Missouri Constitution, not out-of-state interest and not out-of-state money. It empowers every Missourian. And I want to make sure it's very clear about this. This is not a constitutional IP bill. It is statutory. It deals with the laws in regards to collecting of signatures, regarding circulators and things of that nature. The bill has 8 parts, and most of these parts are based upon court precedents. And I will do a quick review of those. So first off, there's a section that deals with the standardization of how the forms are actually collected through the Secretary of State's office. The next part deals with the Missouri Supreme Court decision, and it changes the timeline for constitutional verification. It saves petitioners time and money by checking the constitutional validity of the measures early in the process before the signatures are actually collected, and that only makes sense. Next, and this is one of the more confusing parts to this bill that is misunderstood. It changes the compensation of a petition circulator. It prohibits compensation on a payment per signature. And I'm going to pause there because this has been taken out of context. It is not a complete prohibition on payments. It deals with payments per signature. And that comes from a court precedent right out of the 8th Circuit Court of Appeals from October of 2000. And what the summary in that statement said, Madam Chair, was that there was sufficient evidence to say that there is fraud in the justification, and if you pay per signature, it will result in fraud. The next portion of this deals with how voters' signatures are only counted for what they actually sign. Again, that only makes sense. So if the court changes the official ballot title of the measure, signatures gathered for that measure are invalidated. Next, standing to bring suit, and this goes back to a Missouri Court of Appeals decision back in September of 2022. Only Missouri registered voters may bring suit. So we stop some of the out-of-state interest trying to determine what's taking place within the Missouri Constitution. And then a residency requirement for circulators. They have to be a Missouri resident. That comes from the 8th Circuit Court of Appeals decision. And finally, there's some updates to the criminal codes, and it also deletes the Joint Committee on Legislative Research. There was an amendment that was added in committee. There was also an amendment that was added on the floor. And Madam Chair, if you would like, I can certainly discuss those as well.
Okay, any questions from the committee for the bill handler? Okay, any committee members would like for him to continue? Okay. First witness in support.
Madam Chair, Committee, Trish Vincent, Deputy Secretary of State, and I'm very, very happy to be here in support of Representative Haffner. I'm really, really glad that he presented. He does such a great job. He has all the facts, which is wonderful, wonderful. This particular bill, we've worked with him, and we did work on the amendments as well. This actually adds some efficiencies for our office. And I know it sounds trite, But, you know, when you get a 34-page amendment and it's in 8-point type, trying to read that, so we're you know, making a standardize the way that they have to actually turn it into our office. Additionally, the form. We want enough room so that we can actually read that signature. Now, the form that we are suggesting is currently on our website, but what it does as technology increases, because we actually scan all these through a system, and as technology increases with its expertise, we can actually read those lines, and if it gives us a way to adapt the form with technology. So again, it really makes it wonderful for our office as far as efficiencies. We are expecting signatures. They have to be turned in by May 5th of this year. We may get anywhere from 3 to 4 of those. So the more efficient that we can be so that we can get those out to the offices is really, really critical. When I first came to the Secretary's office, we actually, the prior administration made copies of hundreds of thousands of signatures and mailed them to county clerks. Now we image them in, and we can do a lot more efficiency, and then we have a system that we send them to them online, and we also have an internal system that helps us check those signatures. So again, these efficiencies and this bill would really, really help the Secretary of State's office and our county clerks, I might add. And I'm happy to answer any questions.
Any questions for the witness? Seeing none, next in support.
Thanks, Representative Haffner.
All right. Madam Chairman, members of the committee, Ben Travelis with Missouri Farm Bureau want to go on record in support of this legislation. We as an organization have numerous member-adopted policies in support of reforming the initiative petition process, and of particular reference to this bill, we do have concerns with out-of-state interests getting involved in the signature gathering process, and appreciate Representative Haffner working to address that. With that, I'd be happy to answer any questions.
Any questions from the committee? Seeing none, thank you. Next in support. First in opposition.
Madam Chair, members of the committee, my name's Denise Lieberman. I'm the Director and General Counsel of the Missouri Voter Protection Coalition. We are here in opposition to House Bill 1749. And I want to just note I do have written testimony that's fairly lengthy and cites to a litany of court decisions that helps explain some of the legal issues I'm about to discuss. That I brought enough copies for every member of the committee if you're interested. The Missouri Voter Protection Coalition is here particularly in opposition to the citizenship and residency mandate for initiative petition circulators, which we believe is unconstitutional under both the United States Constitution as well as the Missouri Constitution. We also have concerns about the payment limitation that is not, that also raises some constitutional concerns. And while we understand the pagination requirements that seek to make things run more efficiently in the Secretary of State's office, we don't believe that otherwise valid signatures should be rejected solely because they failure to meet specific pagination requirements. So first, I want to speak specifically to the 30-day residency requirement. Now, while, of course, those who sign an initiative petition must be registered voters of Missouri and therefore Missouri residents, limiting who can circulate petitions for support or disseminate ideas has been found by courts all over this country to infringe on rights of free expression, barring circulators from engaging in political speech that does violate both the Missouri and federal constitutions. Specifically, and I know, Representative, you frequently cited an Eighth Circuit decision from 2001, more than 20 years ago. But what I want to make clear is that since that time, there has become a consensus in the federal courts that a residency requirement for petition gatherers does violate the First Amendment. Just last year, a federal court struck South Dakota's Senate Bill 180 that included an identical 30-day residency requirement for petition signatures. The injunction followed a ruling by the Eighth Circuit that it's from the year before, 20 years after the Eighth Circuit decision that the representative references. The Eighth Circuit, which also binds Missouri, finding that the South Carolina law did likely violate the First Amendment. This case also resolved a parallel challenge to South Dakota's 30-day residency requirement that was brought by the League of Women Voters that the court also found raised valid claims under the First Amendment. And this is because that the United States Supreme Court and the Eighth Circuit Court of Appeals, under whose jurisdiction we're under here in Missouri, have consistently held that initiative petition circulation is core political speech where the First Amendment protection is at its zenith. That is a well-known Supreme Court case known as Buckley, citing another well-known Supreme Court case, Meyer versus Grant. The South Dakota case, Dakotans for Health versus Nome, also referenced it in their Eighth Circuit decision from 2022, as did South Dakota Voice versus Nome from the Eighth Circuit in 2021. Again, both 20 years subsequent to the one Eighth Circuit decision from 2001 that is an outlier in all of this. I will say, in addition, as to the federal Constitution, the 9th, the 1st, the 3rd, the 4th, the 6th, the 7th, and 10th circuits have all concluded, in addition to those decisions by the Eighth Circuit, that residency requirements for initiative petition circulators impose a severe burden on free speech in violation of the First Amendment. And if that's not enough, Missouri's Constitution has been found to be even more protective than the federal Constitution when it comes to free speech, guaranteeing that no law shall be passed impairing the freedom of speech, no matter by what means communicated. The Missouri Supreme Court has concluded that this is at least as expansive as the federal First Amendment. In 2022, in a case that I'm involved in litigating, Missouri Circuit Judge John Beadham blocked a requirement from Missouri House Bill 1878, that was the elections bill from 2022, that voter registration solicitors be registered voters and residents of Missouri, finding that that requirement, quote, mutes speech and expressive activities of individuals not eligible to become voter registration solicitors, infringing on their free speech rights under the Missouri Constitution. Judge Beadham further determined that will remove from the pool of potential solicitors many voting ineligible Missourians and thus restricts the number of voices conveying core political speech and stifling speech. House Bill 1749's residency and citizenship requirements would bar a large swath of people from engaging in core political speech, including by people who may have first moved to Missouri, but who will be affected by these initiative petitions, and thereby reduce the pool of individuals. I also want to make a statement about the payment restrictions. I know there's been a lot of talk about the potential constitutionality of the provision in the bill that would bar paying a petition circulator based on the number of signatures they collect. There have been some court cases upholding those kinds of requirements. However, they have all made clear that these kinds of requirements are not per se constitutional. So, for example, last year, the court in Pierce versus Jacobson, which is a case out of Montana, while the court there upheld a ban on paying people based on the number of signatures, what the court said was that the plaintiffs in that case had failed to demonstrate that it actually burdened their ability to get their message out. In that particular case, there was only one person in the state of Montana who was being paid, and so she was not able to demonstrate that it was a burden. The Ninth Circuit made clear, quote, to be sure it is possible for payment restrictions to impose a severe burden and be unconstitutional. So these are two very significant legal red flags that stand to impede this legislation, that are both open to litigation, and I assure you that the 30-day residency and citizenship requirement for petition circulators will be subject to litigation, and will be found unconstitutional should this measure pass. More broadly, we shouldn't be limiting public participation in the citizen initiative process. It's the most purest form of democratic participation, allowing citizens to engage in conversation with one another and raise issues of public concern. And so, for those reasons, the Missouri Voter Protection Coalition stands in opposition to this measure.
Thank you. Any questions? Senator Coleman.
I apologize. I was needed for a vote in the other room, and
I
so I
understand.
always feel like I'm bumping between these two rooms at this time frame. Remind me, South Dakota isn't in the Eighth Circuit, right? So although they were giving favorable treatment to the finding, it isn't actually binding on the state. Isn't that right?
No, that's not correct. The Eighth Circuit did issue an injunction.
Okay.
And concluded that that
Can
the
you
measure.
get me the citations for all of those cases that you've cited, please?
You bet I can. I brought you a copy
Perfect.
right here, Senator
I
Coleman.
appreciate it very much. I find that to be more helpful sometimes than the verbal testimony.
I do too. I spent most of the weekend rereading these cases.
Well, and as a lawyer, I just like to read it. I think that it is incumbent upon us to represent our clients in a way that is most favorable to their position, and I often reach different conclusions than testifying lawyers when I look at the case law, so it helps me to be able to see it. Thank you.
And I'm here as a legal scholar on voting rights, and so I don't take any particular position on behalf of clients in this matter. What I do is look at the case law.
No, hold on. You're here on behalf of a client testifying, and your legal opinion is for their benefit. So I'm just going to push back, and I appreciate it. I don't want to take any more of the
Sure.
committee's time. We have a number of people to get to. Thank you.
I wouldn't offer a legal conclusion that I did not think was truly found in the case law.
I apologize sincerely if you think that that was in any way besmirching your reputation. I think that we are all called to be zealous advocates for our clients, and it was a recognition that we often reach different conclusions based on the lens through which we read the cases. So
Sure,
I appreciate your testimony. Thank you.
I do want to clarify, Madam Chairman, that I am not a lobbyist, and I am not here today in that capacity. I am here as the representative of my organization.
Thank you. Any other questions for the witness? Seeing none, thank you. Next in opposition.
Madam Chair,
Yes.
may I approach to share copies of this with the
Yes,
senators?
if you just want to leave them, Senator Koenig will pass them down the line. Yeah. Thank you. Next in opposition of House Bill 1749.
Madam Chair, members of the committee, my name is Jeff Smith. I am a lobbyist representing the ACLU, and I almost always believe exactly what my clients say. So anyway, we submit testimony in opposition to HB 1749, which we believe would hinder access to Missourians' constitutional right to citizen initiative petitions. I know Representative Haffner has worked for years to try to get this language right. I know he's one of the hardest workers in the chamber, but we do have concerns around a couple specific areas, and I want to just single out one of them, which I think is our greatest concern today. To refresh, the ACLU works in the courts, in the legislature, in communities to try to preserve the civil rights of people, in particular the right to vote. The IP process is an essential form of direct democracy, and for over a century, Missourians from all across the political spectrum have employed the process to advance key causes important to them. But if passed, we fear that HB 1749 would undermine this right by expanding the powers of partisan office holders, the Secretary of State's office and the Attorney General's office, in their roles certifying a petition for the ballot. Rather than reviewing petitions as current statute provides for proper form, this bill changes that and expands the roles of the Secretary of State and Attorney General to review the content of the petition for compliance with statutory and constitutional provisions. This is far beyond a review for form, and we fear that it would install partisan politicians as essential gatekeepers for the initiative petition process, giving them the power to grant or deny access to what should be a right of the people. We've seen just in this last year a Republican state auditor have concerns about the inappropriate interference of the Attorney General in this process already, and so we don't think these concerns are unfounded, and firmly believe that rights shouldn't depend on the personal or political predispositions of a particular elected official, which is why we oppose HB 1749.
Thank you. Any questions for the witness? Seeing none, thank you.
Thank you.
Next in opposition. You may begin when you're ready, sir.
Thank you. Madam Chair, members of the committee, Sam Licklider here representing Missouri Realtors in opposition to this and frankly in any changes to the initiative process. Representative Haffner has, as always, done a yeoman's job in making this as correct as he can, but it's a tricky thing. The Constitution and both Constitutions and I'm not going to try to convince you of any particular thing except one. If you read Drebs this morning, you will notice that Missouri Realtors are opposed to this. We continue to be opposed to this, and we'll hire attorneys. I'm not an attorney, I hire them. And see you in court.
Almost choked on that.
That's it.
Any questions for, from the committee for Mr. Licklider? Seeing none, thank you, sir.
Thank you.
Next in opposition. You may begin when you're ready.
Madam Chair, members of the committee, how could you follow Sam's testimony? Auto Fains on behalf of Missouri NEA. I intend to be very brief because we really want to just highlight the same concern that the ACLU witness highlighted, which was changing the role of certain partisan elected officials with regard to the initiative petition process. Ironically, one of the ones that's referenced is Article 3, Section 49, which speaks to the people reserving that right independent of the General Assembly. But I think we would echo the concern that that really opens up requiring them to make their determination of compliance on those constitutional provisions, which have language that folks might disagree on, and it's probably better for the people voting on the issue and the judiciary ultimately, if there still remain legal questions, to be the arbiters of that, rather than having that essentially gatekeep the initiative petition process and what the public might have the ability to consider in an initiative petition. With that, happy to take any questions.
Any questions from the committee? Seeing none, thank you.
Thank you, Madam Chair.
Next in opposition.
Madam Chair, members of the committee, my name is Ron Berry. I'm here on behalf of Jobs with Justice Voter Action. We'd just like to go on the record in opposition to this bill. There's a couple things that are in the bill that are already current law, such as if you collect signatures on a summary statement or a fiscal note that has not been vetted through the court process and any changes, those signatures don't count today. So that's something that's already in law. Also, it's interesting when we talk about vetting that you want to delete the one vetting process that we currently have with regards to the initiative petition process. It's, to my knowledge, this, I think, went back into effect in 2012, where the joint committee would hear those petitions in an open forum or a committee hearing. And yet you want to delete that. Also, we are very concerned about the possibility that the changes to determining the form of the petition would maybe perhaps politicize the system even more than perhaps it already is. And with regards to pay, I don't know if you're going to be able to try to, if you want to do it just by signature or how you want to limit the pay, but the guy that's down at the end of the street here at High Street in Madison, he's getting $20 an hour right now to collect signatures. Right down, right down there at High End Madison. He's collecting signatures for the casino.
Any questions for the witness?
Thank you.
Okay, seeing none. Next in opposition.
Madam Chair, members, thank you for the opportunity. My name is Elizabeth Franklin. I am not a lobbyist. I'm not a lawyer. I am testifying on my own behalf after my little 182-mile drive down here today. I do oppose House Bill 1749 in its entirety. While Senator Black's bill is meant to include the military and accept their talents, this bill excludes them and hinders their ability to participate. There's no good reason to require a 30-day residency and to not pay by the signature. Active military and families transferring to Missouri is common. Spouses need immediate ability to find part-time work. Petition work is ideal. It's flexible. It allows for childcare, running kids to and from school while they look for full-time work. This bill refuses their participation for 30 days. As a veteran, that concerns me. Did you know that 45% of school children in the DoD system are on free or reduced price lunches? Did you know that 24% of active military are food insecure? Why disallow their ability to earn money through petition work or their spouses? Eating does not take a 30-day waiting period. My strong recommendation: remove the 30-day residency requirement, remove the pay per signature restrictions. Think about who that impacts. As a young lieutenant at Fort Stewart, Georgia, I saw these issues firsthand. I had soldiers in my unit struggling to pay for food, fuel, and other necessities. Missouri should not be the state who pushes away these families that serve our nation. Amend or kill this bill, please. Thank you.
Any questions from the committee? Seeing none. Next in opposition.
Good afternoon again. Marilyn McLeod for the League of Women Voters of Missouri. Thank you for this opportunity. The League of Women Voters is opposed to this bill. I'm also not a lawyer or a lobbyist, just representing a group of folks who are just so supportive of the rights of the people and to vote and to the access to direct democracy, which an initiative petition is a right provided by our Constitution. All of these efforts to try to put barriers in front of the citizens is deplorable, frankly. We need to find ways to make it easier for people to address their elected representatives and to express what they want to happen. The reason that people resort to initiative petition, particularly for Constitution, is astonishing that they do that because it is so difficult. And to put extra barriers in front of people is just, I have no word for it. The citizen initiative process provides direct citizen representation. You know, it is extremely difficult to come and testify here in the Senate. We have to be here in person. Makes it very hard for individual citizens to express their concerns. This particular bill was heard in the House, and the House does have a portal where people can enter their testimony. For this bill, 451 people submitted testimony in basically about a 24-hour period. Of that number, only 6 testified in favor of the bill. The remainder were either opposed or for information only, and the 2 testimonies that were submitted for information only actually said they were opposed to the legislation. Legislators complain that the Constitution has too many additions that have been approved via ballot issues. Over the last century, more than 300 constitutional amendments have been proposed. The majority of these have been placed by the General Assembly compared to those by citizen initiative petition. 246 by General Assembly versus 70 by the people. The General Assembly uses a process that is far simpler than the one required for the citizen initiative. HB 1749 proposes additional barriers to increase limitations on the IP process. I must note that there does not appear to be any effort to make the process more complicated for the General Assembly to put a bill on the ballot. While it's an improvement to be able to print out the petition forms electronically, the League believes it would be an even greater improvement to allow citizens to sign petitions digitally. That would save money and expand access to all parts of the state. And those are two of the concerns that keep coming up, that it's an extremely expensive process and that not everybody in the state gets to sign. And so that would be a way to do it. In summary, the League of Women Voters of Missouri opposes any attempts to make it more difficult to get a citizen initiative measure on the ballot. You should be doing more to encourage the participation of citizens, not setting up barriers to discourage them from participating. Thank you very much.
Any questions for this witness? Seeing none. Next in opposition. One more time. Next in opposition. Informational purposes only.
Hello, Nancy Copenhaver from Moberly, speaking as an individual. For information only, just one particular point I would like to address, and that is the ongoing emphasis on the fact that we don't want out-of-state influence or out-of-state money coming in to affect our elections. And I've always been a little bit upset when, for instance, I belong to an organization, Missouri NEA, which is a branch of the National Education Association. And for many, many years, I've paid my dues locally, state, and national, and I've given PAC money to those organizations. And oftentimes when there is an issue that comes up that educators feel very strongly about, we all work together to get something done. And we might help somebody in another state, they might help us. We pool our money to do that. And if, for instance, NEA money comes in at $1 million to help with an issue that Missouri teachers are working on, I think that is partly my money, and I don't really think that infringes on anything. I'm also a Presbyterian, and I give money to various Presbyterian issues that use the money in mass to do those kinds of things. So I think we have to be careful when we say out-of-state influences, that maybe it isn't always that, maybe it's just part of us. Thank you for allowing me to say that.
Any questions? Yes, Senator Washington.
Thank you, Madam Chair. Thank you for being here today, ma'am, and thank you for your comments. Going outside of the NEA, what are your thoughts on outside financial influences like campaign donations to candidates that come from outside the state? Do you think that's okay, or should we treat outside donations for our initiative petition campaigns the same as we treat money from outside the state for our candidates?
I think that's a very good point, and I don't know how on earth we would ever get to that point. For instance, when I ran for office, I had relatives who lived out of state who sent me money. I don't think we should be opposed to that kind of thing. But you're right, this is setting up a difference in that regard, too.
Thank you. And
I
second
don't
question,
think we
do
could-
you think that takes the voice away from just a regular citizen like yourself versus those of us who are actually holding office?
Say that again?
Do you think allowing one entity like candidates to get out-of-state money versus what this bill would do would be preventing out-of-state funding for any initiative petition processes treats candidates or elected officials different than the regular citizens
Yes,
that
I
sent
guess
us
it would.
here? Thank you.
Thank you.
Are there any other questions for the witness? Seeing none, thank you. And do you have some Closing comments, Representative.
Well, Madam Chair, just three quick comments.
Okay.
And first of all, I'd like to say, as a 20-year combat veteran and a forward deployed combat commander, I did everything in my power to enhance the opportunity for my troopers to vote in the elections. For 20 years, I've voted absentee because I spent so much time at sea, and I would never restrict that right. To members of the committee, the Secretary of State's Office of Legal team provided me ample information. I would be glad to answer any questions that you have. I think there were some things taken way out of context here. And just to be brief, first of all, the specific case dealing with the League of Women Voters, what wasn't told you was that both parties agreed to dismiss the case back in January 2023 in regards to specifically the compensation of the petition circulators. And the Eighth Circuit Court of Appeals is the precedent case, and I would be more than willing to hand that to you. In addition, the Buckley decision at the Supreme Court decision would also be pertinent in this case. I'd provide you a copy of that as well. So not only is the compensation for the petition circulators what I stated accurate in prohibiting compensation payment per signature, it is applicable. And I'm going to read one quick comment from the residency requirement for circulators dealing with the Eighth Circuit Court of Appeals. It said very cleanly, we conclude that the residency requirement is constitutional. I'll be more than willing to provide any case information that I can. Thank you. Thanks for hearing the bill.
Thank you, Representative. Now we're going to hear Representative Taylor. He is going to present House Bill 1909. And you may begin when you're ready, sir.
Thank you, Madam Chair, members of the committee. Representative Tim Taylor representing the 48th District, which includes Cooper, Howard, Sheridan, and Western Randolph. You have before you House Bill 1909. It's pretty simple, really. Currently, state statute says in the years when a primary election is held pursuant to subsection 2 of section 115-121, each county committee shall meet at the county seat on the third Tuesday in August. We had a situation in Cooper County about a year ago where the Central Committee had to come together to decide to make a recommendation to the governor for vacancy that happened in the county. Many people were reading that line as that all meetings of the committees had to happen in the county seat. And so I looked into this a little bit further, and it came to my mind that I think this is a bit outdated, and that perhaps striking the requirement to meet in the county seat is more conducive to today's modern society, and that this might be a remnant from even the horse and buggy days. COVID also brought to light that we have many ways of meeting these days, and that one line really doesn't allow for Zoom meetings, and it doesn't allow for the flexibility for committees to decide where they want to meet, and also with the increased security of current courthouses, this would also provide that ability that they can meet outside of the courthouse, which would ease much of their burden. What it doesn't do is it doesn't change anything else. Those requirements to provide free space to committees, political committees, for meetings is still there. So really it is that simple. And I would stop there and answer any questions.
Any questions from the committee? Yes, Senator Washington.
Hi, thank you, Representative Taylor, for being here. As I'm skimming through this, I'm on old glasses. I broke my glasses. This initial bill, initial statute just talks about one meeting, the third Thursday. And it seems to me that you may be talking about all of the county's meetings.
It was, so this statute only refers to that requirement of that one meeting taking place in the county seat. All others, as was defined, don't have to happen in the county seat. They can happen in other places, but many people were misinterpreting that every meeting had to take place in the county seat, which is what really led me to look into that.
Well, I can't help with somebody's interpretation. I'm a lawyer, and this, just reading this statute, there is no confusion that that is only for the one meeting, that is the third Tuesday of August, which, as we commonly know, is an election day. So are you suggesting that we have our primary election somewhere outside of the county seat?
No. This election still takes place. This is just the meeting of the Central Committee, whose responsibility at this time is to restructure, to develop their leadership. This is after the primary election.
Okay, so shouldn't it be that, and I see, do you represent the city of St. Louis at all?
No, ma'am.
So why is it that you're taking that out?
Just in that
We
if we're
just
gonna-
here, we have kind of like a gentleman's agreement that we kind of don't delve into other people's communities because we don't represent those communities, so we don't know what those issues are. Had folks from St. Louis City in the House, what was their opinion on that?
Actually, there was really not any opposition to this. This came through consent, so there was no opposing.
Did you talk
votes
to them
that.
before doing this bill?
I didn't. The reason why we included St. Louis City is because we were including all of the counties and to keep St. Louis City as part and part with all the rest of the state.
Okay,
That's
well,
why we
for my
struck that
county,
out.
my committee, they would not like this. So can we work together and maybe do this where a county has a choice? Because we do Zoom meetings, and they are not against any statute. They are not against the Constitution. So that provides me an opportunity to do those meetings while I'm still here. And I know that other counties do those as well. But this, although I understand your county did have an issue, that may not be a total issue with the state. So maybe we can allow counties to have their choices as opposed to just mandating that they take it out of the county seats. And furthermore, as an attorney, I know that we need that as we're moving towards Zoom and more electronic, non-in-person things, we need somebody to go to those courthouses where most county seats are to keep them going. But thank you for bringing that today.
Certainly.
Any other questions or comments from the committee? Yes, Senator Crawford.
Thank you, Madam Chair. Just a quick question. Did you have any input, or did you reach out to the state committee of either party to get their input, or did they make any input to
They
this?
did make input, and there was no opposition that I received. for
And was
this.
that Republican and Democrat, or was it just Republican? Or I'm just curious.
Senator, I didn't specifically reach out to them and say, what do you think? I did get input from central committees around the state. And honestly, I found out that many central committees aren't following the statute the way it's written
Okay.
anyway.
So you didn't
at
really
this
have
point.
specific input from the state party,
I did
you just
not.
did from the central committees?
Yes, ma'am.
Okay, I was just curious. Thank you.
Any other questions for the bill handler? Seeing none. First witness in support. Okay. First witness in opposition. First witness, informational purposes only. Yeah.
Sorry,
yeah.
I couldn't live up to the last bill's standards.
That's okay.
I apologize.
That's all right. And do you have some closing comments, sir?
No, I would just like to thank you all for bringing this up and letting it be heard in committee for the discussion. I really appreciate that. Thank you.
Okay, thank you. There is a quorum present, and so we're going to move to go into executive session. Do I have a second? All in favor? All opposed? The ayes have it. Senate Bill 724, I move that we take this bill up. Do I have a second? All in favor, say aye. All opposed, say no. The ayes have it. This is Senator Hoskins' bill relating to elections. Is there any discussion on this bill? Any discussion? Okay. I move that we vote Senate Bill 724 out of committee. Do pass. Do I have a second? Is there any discussion? Okay, Madam Secretary, please call the roll.
Senator Gannon.
Aye.
Senator Crawford. Senator Carter. Senator Coleman. Senator Koenig. Senator Rizzo. Senator Washington.
No.
Okay. And the bill passes 4-1, I believe. Okay? And that is the conclusion of our committee meeting today. Thank you for being here.